Yo, for me Mama Kwaba about the Law Lab YouTube channel. Say welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. Mediane Aaron Asiedu entry. This week has been quite disturbing. Disturbing in the sense that issues be air coso and there is a trial in the United States of America between a seasoned journalist, Anas Aremeyaw Anas, and the Honorable Ohene Agyepong. This matter has caused a lot of stir in the media. Obi can say Akosiha, Obi can say Akosia, Obi say Honorable Ohene Agyepong. In fact, Anas Aremeyaw team, can say ya award damages of $18 million. Almost support Honorable Ohene Agyepong and as almost join the home sympathizer with or so also say a case for mistrial or more apply for mistrial. Now the problem is mistrial no crano and any day. Mistrial no and on a day. So today we are going to look at mistrial in the light of the case of Anas Aremeyaw Anas. We are looking at mistrial in light of the case of Anas Aremeyaw Anas versus Kennedy Ohene Agyepong. Na ye kobe nyina wonim se ye hia obi a onim mmra not emrase no betimi akire yemu ameate ase. We have here on the Law Lab Mranimni lawyer Kwesi Kwati is a former PRO chief Akwaba. Hey, former PRO for Ministry of Education, right? Or spokesperson for the ministry. Akwaba.
Minya lawyer kuma.
Menye lawyer.
Say they are lawyer ntino wona nkwa so.
Share dey me school ni.
Do your lawyer kuma school ni dey your lawyer kuma wo fe oba man na fe lawyer.
From who definition? Impassive.
Only him pay zero legal counsel for.
Akwaba high Law Lab, high we dissect and unpack everything legal. For before say better as no. Measure mo Matias say apamocho say more like subscribe, share and comment. Catch your down for say lawyer Kwesi Kwati abeka yensa. Obeboye ameyate mistrial ase. In fact, obeboye ameyate mistrial no in the context of Ghana. If we are near the accord in the context of the US pursuant to the case of Anas Aremeyaw Anas. Mini epeni mema o afra review.
Yeah,
na Yenka bin Shemuna na watching. I think say in the year 2018, we had the background of the story. In the year 2018, say Anas Aremeyaw Anas the some documentary bia or the Babontia popularly was titled as Number 12. Number 12 na say 11 players and a field so into number 12 bi techira e bia wotwetwe homa e ma de kofa nsem bebre e ma Ghana ye ball bosem no obi abedi hu adanse say from that time till now no say be ye ball bosem no kra no enhye da ngina abrane e ma trene ana apeni kwankyerefo a na oda GF Ghana Football Association ye wo 3 no e ma ne de ne kugina se ni bia ya toto na no. I think say recently in the case no ye the case no court abo asem nego ye Ira Kwesi Nyantechi lawyer Kwesi Nyantechi asem na make bra asem ne bae no Ira Kennedy Agyepong mounted a spirited defense in the matter. Say he doesn't believe in the credibility of Anas Aremeyaw Anas. A reason same bebre both in Ghana and madidi kupie amanone kra madadi friend show so okay can same bebre. In fact, that time no Ira Kennedy Agyepong say etifo ebekaya oyi video bi wo Madina your friend who watches the watchman ana o kire say Anas Aremeyaw Anas ye kan ho asem no Anas ono no e kan kofo ho asem no no. It is a clear case say ono amu na nkasa enye credible. Who watches the watchman ono no da na ho watchman a no hwe obi a ono nso se wasokane ato Ghana said the beya akro katasese any proye ebi enko inka bi nshim things in 2018 in and on and about June thereabout Ira Kennedy Agyepong ekupi the United States of America ewo ne residence maybe on one fee wato dan out te ho here on one property in New Jersey Emma. I think say one of these Facebook conversations between ono anyone that the friend case mokeka nsem bia Ira Anas Aremeyaw ne boanjo so a or maintaining an action against him in the United States. May come at you for what you say case ni be Anas maintaining case ni be another assembly be echo court e Ghana and when I think the obi a yellow obi would get a clear indication say court na e de ba abonte no you get to know say the ruling didn't go in favor of Anas but na trial on buso koso e United States this week and I yate ababonte say from Tiger IPI, I'm having the statement over here. I think it's in due course. Now read it. On my etia say we need judgment. Etia Yera Kennedy, a compreko Japan. Narrates of summons or the coin. No demand there for $30 million. But court amani $18 million. Meaning a seminal angasa et saying.
Minya medase. Na mebo abaso ewo dwumadi a wodi. Yemu wo ha ebu ha ye penim de bia law lab na eba na
medase bru
because penimfo atitru wa odi omobaso no titru wa odi omobaso no wono mo odu pa
sure
na mu se enua pani lawyer attach anu wo so
sure
a wono mo kira de nti yemu bu a ya na ekokasa TV so ni a ne bu e be law lab asana yetimanya ho nim de
that was
na ya de konti yero ho
that was
when say bedroom me bi na apeja ye kese pa na Ghana how be hwe legal platform ya na law lab
Mother Romane mo resource persons mo mam ho kwan say mo ne ba be share this knowledge na you to be damase and the team na be dawase
na correct me so en munyam say mame me hu amani age pa
sure
now to the substantive issue me dey say okofa ba be asem ne dey efree na mrenti no mensa and go into the facts of the matter again na mo made ba ko a pese me twe etiefo nyina adwen ba so ya de ba ko pe asem ne ba ye no ye bekom say whether is a judgment or is a verdict of the court mze bekom emum enipa no bebre esusu say ewura Anas odi kan de asem no kra ba Ghana court na sabi ebru Ghana court ye ne basa ana odi asem no koda America court na ye agiatum woni nipa no bebre twhwem komo a sa na on monte ase
that is a perception in town
yes because one mo enti ase no nyina koyese ensema ho kan say na Ghana got ye de enka no kre and very unfortunately Anas no mpo a sabi ebru oye lawyer ni SIA journalist onim bibia broni beka as a fair reportage and responsible reportage the true intent and the motive of the story ne eba no kra no ne nchire mu no se bieburu kame akoye se eno kra ka ho bi na manfo nya sa adwe no na ye frɛ bibi se spinning of a story ma nchire mu kakra spinning of the story se bieburu ye nim saka mam ye de ntoma tuntum na ye de ekwayiye no hu so obi kufra ntoma tuntum na ntoma tuntum mo se ntoma tuntum ye frɛ anepa semasi de che se enipa ye de ewu fi ho nya yi azu behwem no no frɛ ntoma tuntum so bia no kosi here
okay
but the ntoma tuntum na eye foundation no ana ode bibia ye de atare so ti wa hwe omanfo na adwini na abayom sampa ntoma tuntum dia o frɛ tuntum ye se yi ye de aba ho azu aka mamu no se hina de tuntum na ye de esi na me ka kosi se
ubube
yes
ubu ye be
me ka kosi se ye ka emramu ene mramu nhyehyɛ ya broni beka se laws are territorial enti ye ka se territorial oman bia wore territories Ghana man no ye oba bia Ghana man ye de epem na ye mra ye de adwuma no epem Ghana hankwa sa ba person na okwa American so laws within the confines of America
the United States
mramu no ye beka se ebi kura no kwa de ebia within the jurisdiction of America enti ade a sebi eburu yatintim nkrata so agiatum se mra wa ha bi kura beko America na nyamra ye de ewo ho na ye twe adwen se bibi so ye kura de a ukwa America kura ma ono mo system no mo practice federal system ono kura de states be 50 states and 51 states e wa America no kura 50 states e wa America no kura de ono mo kura no beko no na ebi wo ho a mra ewo bibi wrong wo Florida ebi a obeba Massachusetts no na ebi a LGBT who said go
try classical
example baby how much you baby so mo yede omo nyintum enti at no point ana ade a sebi eburu Ghana mramu no yatintim say ebi a mra wa ha na it constitutes a ground or it constitutes an offense no obetima try no America na ebi say na ye dey na Ghana for me no mo eni o masem ha no mo de call America
That is an essential question.
Yes. Then nipa Ghana from you know enti many o masem Muhammad ko America. Ade ba ko say what tia say me sika say laws are territorial. They operate within the jurisdiction no. I just say when an offense takes place within the jurisdiction and within the boundaries of a certain country and I say one more akachia a home run e dey adwuma. The Ghana from you know ko America. Na ba ko kwetwe second ba ko so a yen kan jom so mo ye Ghana fo ntia de o mo ba Ghana we dey abidio masem America ni ba Ghana ha no tuka no wantu ni ye no de ka ko bo Ghana ni na Ghana ni se bitima ya de hamra na be dey e be adwuma.
I think that there are a few exceptions.
Yes, because the offense took place within the jurisdiction of Ghana. Mejitum say ampa there are few exceptions because there were enfonso bia ene de wiase nyina jitum say enfonso a we are asase so bebia no enye ai ho de nyina etimi try eno ebia bibi dey say piracy bibi dey say slavery paniary no money ade no ho de it doesn't matter where it occurs bebia osie bia wonu mutimi ye the country bia okoye na America ha Ghana kwa betima achew e de wa face the judicial system because of international treaties no money ade wo ho a nyina agya tum say ade we de ukomukwa international they will tell you they are the juice cogent norms
juice cogent
norms no dey onu nyina agitum say we are seeing nyina no no dey enye but now we are limiting ourselves to the usual civil and criminal trials ewo oman no ebia no
meba o say woka civil and criminal kiremu kitu abi ansana wakba abekiremu de entia Kennedy Ohene Agyepong obi anim so free asen na Anas Aremeyaw so free krom ha mumie no ko wie ewo US court
the etia say ka civil simple civil no say yeti krom ha na bia kromafo no ana say nipa ewo krom ho no individual say ho no nipa mienu enya omo amo ntem asem tia omo ho na omo pese ye famra kwa so ye dey edie enti me no tu ye nya asem a ye de be court me no mienu bi asebia buru wa bagimi sika wantwia ana se bia eno ne asem no
because oka asem a nipa bibiri hu ne say abama ne
abama ne no eno ene ya criminal no na just a criminal no kra no ye wo enfunso bi wo ho a ana offenses bi wo ho a eno de ahyehye say sanfunso we ana offenses wo yetia wo ho kra ende mu odu pa enti eno no aban ne begina nipa na wo de saa de na ye de edine na ye de achi fa ne se waku obi eno ye nka nche wo say eye several asem da bi enye nipa mienu entema ye de asem na say obi de obi ka obi ni obi ye nhyehyeye bi na nkoyi ebi a contract bi ebi a oton asase bi hu
so ba bo so be ware no wan ware na
o sure ba bo so ware
which of promise to marry
and say several eno de several
but criminal na ye te say we wi obi ade
yes
okay
a criminal we wi obi ade ebi okotutu abo obi ohu o de car ko bo obi so ye wo normal be bre o why no so constitution criminal say treason money ade
what try ban mu
yes what don suffer ban say ka ade bia o man na say no no hu say e ka man no in a way no even though e can nipa dua bi no but the ka man no you know man hwe ensisi entimi nka say no ye momu ntem asem da bi several no ye nipa mo am ntem ayede asem am nkoka mo say no obi no ne mo ba criminal de a mo am ntem asem I say be bu obi akọ repo bi mo ntem asem ne say because enya de obi abeji repo ayede atomo ewo wiase nyina nti en de aban no ye de eba mu enti sa nkyere mu no minim se me firu ha na metima atoa asem America
so clearly no Kennedy ene yera Anas ne Kennedy asem
civil matter
civil
yes civil matter
ko wie US adentina so o maintain bi wo Ghana ene odi bi nso in fact o institute action bi wo Ghana ene o institute bi wo US aden no ko US
anu ntina na me che say medical case crimes or offenses not even crimes offenses are and even laws are territorially bound enti ade a esi wa ha a ye mra kasetian eno kwa na obetimi di akọ Ghana court enti se obi ye bibu o Ghana ha wontimi mfa saa asem no kwa America
general perspective
yes general perspective America aban ne de animal saa bebe so na Ghana ni bi kura na se broni bi ko obi aso America wontimi mfa ne ma Ghana ha se ne kurom ne Ghana nti obede obedi be offense ne take place no eno nti ana menne nipa bibire a wono ma spend story ne nya adwen se ase wono mo di assembly o Ghana ha the nipa no ye Ghana court no ye de basa no wotam assembly ko America it can never be the case because an offense that is committed within the jurisdictions and territories of Ghana no cannot be heard in any court in the US and vice versa and it can only mean say assembly see o Ghana ha no based on different facts and a constitutes our offense no.
Okay.
Now American so one so assembly see and so were based on different facts and a constitute offense no. Within the instant case no, America then Iraq and Japan or America. Or Ghana knew all right. And also Ghana knew on Munina. So far as we know, and the reports have it, none of them has denied their citizenship. So what are Ghana for? Now, one would do a muddi and one my brother Bobby Bray or America. Now, Obi to say Iraq and Japan will feel America. And now so baby on also a tell. Now, Iraq and Japan or America, and I said, we see Chimano, or where interview be America. And interestingly, I did say for Adrian Basson said, Nipanukaza knows a interview, no, so now America could more.
Okay.
So it can be said that the offense was committed within the jurisdiction of America. Okay. And so for that matter, the courts in America had jurisdiction to hear the matter. And to no other court but the courts of America. And until now, Assembly Ghana from Unia Assembly Day, America. No. I say Ghana from Ununa, Obi, Akobo, be assume America. Then can't some Ghana from Chombraha. Yeah, the American man every day, a video on Master by day. Amom. Oh, America now, a Ghana, Nina, Uko, BT traffic. I got also a Ghana in TV from Brokum. There be the American man every day, a bid you as
for the purpose of education, or the case, was maintained in the court of excess county superior court.
Yes.
What the state of New Jersey. Zemera American New Jersey.
Yes.
Jersey.
Yes.
Jersey.
Because the entire man I say.
Okay.
Offense na nkasa kwa na ehona take place New Jersey hono.
Okay.
Na Kenya Japan so kwa no so ye defendant in the matter no. New Jersey also no so tena ete ni fie ho. Ehon kwa so sa try interview no.
Okay.
A constitute defamation no. So na mpebere no ya na confusion here say Oka America, it was a same offense, defamation. And Ghana said it was the same offense, defamation. Then said the music say, or maybe I know the burden of proof, defamation in America, and the same thing Ghana. So in the burden of proof, no, even a different. Even the elements of the offense, so proof, no, it may be different because or maybe our Mray so when people say so, yeah, the Ghana and the Entume America, first the facts are not the same, even though the offense were stated same offense, but the particulars of the offense were different. The particulars of the offense were different. And again, I did also Adrian Basson say, Abipiano, who do you mean compare jury trial to Sebia Bro, a trial with the bench?
I was coming there. Oba Ghana. Jury, I think criminal matters.
Yes.
And criminal matters, Oba Ghana, and all criminal matters, criminal matters which are first degree felony or punished by death.
Yes.
Intimidation, murder, rape, all these things.
Indictable offenses.
Indictable offenses. So you go by the bill of indictment, obey or charge sheet, or the summary of evidence in a be attached and as for. But Oba civil case, there, a judge and a tenaso, a may intention, may court be an judge, a handle all civil matters. Yes. So I was quite surprised. Say in a civil matter like defamation, we had a jury trial. The lawyer, me person Uchire Imune said, what is the difference between having a jury trial and how does it look like? And it also affirms a point say, Mrebia because Ghana about civil matters we don't do any jury trial. Yeah, whom be say America, yeah, who say some of the jury civil matters, they do jury trial.
Yes.
So what is the difference between this jury trial and the normal bench trial?
I did also say first of all, there were two types of trial. There were Uba Ghana Krana, even your normal criminal proceedings, there will be a friend summary trial, and there are also trial by indictment. Summary trial and they who say assembly, even though you've committed the offense, but a mudrono, a bonenkete. I know the pentem crana court tonight the wasam because benefocus a justice delayed is also justice denied. Na yenhwe day and quantum. Ti no judge ba ko na empepini ano day or transfer. E bia those petty theft and money are done quickly na judge na di no day no transfer or call. Na ye wo ba ko say friend try
theft the be ni your system ye ni
yes ye ni but me cannot yes for the purpose of the understanding of a layman say basic boning get so bia ko twa obi there e bia assault obi akobo obi asum no ne sa no mano quickly na yahwe na ye yefro na ye dey neko na trial by indictment and also usually when the offenses are so grave and man also set a certain threshold say dey asem no sebio one we punishment kra ye dey ebema accused person no e wo mu no see a mistake pe never say most of them are first degree felonies when you be up to 25 years now 25 years now one hwehwe mu pa anti the perspective of also the people living within the community na one hwe na tenche dey aba they are paper you know no one mo de bibi e friend jury na de ba ko ese hu say jury no na one mo enye a lawyer for one mo enye people with any legal background but we want them to have a fair appreciation of the facts, not the law. Nti one more dey say the facts of the matter no ma betra ho. Asem na no ma beti no ma he. Na ebusan say an ordinary person no better say same way no. An ordinary person on the street no. How will he judge or determine such a matter? Okay. So that's how we bring the jury in. So the jury are there just to help the judge in making a decision. But the jury is work, limited to the facts within the matter whilst the judge applies the law. The judge, the emrano, say, any point of law, be a what trial, a judge and a church no making ruling or determination on it. The judge knows what the work of the jury. The jury, and so at the facts now, into most of them, it be a say, is a person guilty or not guilty? To be able to be a jury, no be a 7-1 decision, which are 8-0 unanimous decision. There's a jury,
jury number 7. Ghana.
No, Ghana is 7.
Yes.
It can be more than 7. But America, no, one more system is different. And tell me, you can say, in my background, some come on and say, but I see API, I see a test, I say, could be an number. And the over Ghana, before jury better person, only in criminal matters. In civil matters, some crime, you know, and then your assembly. And prepare a judge back on already, or test what. I say be a brew or Supreme Court and no near the and be a court of appeal near the but no say no so one Supreme Court no within the constitutional framework and also a number of judges that they have to set to empanel. I know by constitution say they are properly constituted as a panel to hear the matter. And that
one ordinarily they should be 5.
Yes.
At least.
Yes.
They should be 5.
Yes. And no yes I jury na a free way but bench na one more day e bia no na be because of also a constitutional requirement on my day or more a chance almost here dey asem no.
I think the lawyer nya santi clearly. I want us to look at the matter. My kind written.
Yes.
What kind written na yera Anas Aremeyaw Anas. They now all free court on say will receive 5 counts.
Yes.
It's ya counter or boko edu maku enum e de etia yera Kennedy. Ohene Agyepong.
Yes.
Na asemo kan say out of sa akwa edunuma ye boy. Ohia se court ebeje every year Kennedy Ohene Agyepong ho million mako sa eduasa $30 million.
Yes.
Then at $30 million ye be $18 million. Na mo nso mo kan ensemfo fro se be ene de ekoso Kennedy cheater for me wo se wankasa wo ba Facebook betro say the Anas can enye no crap. I want to understand what happened in the court because what can show you to say here Anas Aremeyaw explaining the fact.
Yes.
In teacher the see what court reporter and then a court neka and why are you saying that Anas Aremeyaw with the Tiger IPI may refer to the statement? There was a statement on the judgment. Statement of on the judgment, if I may refer to it, was a statement on the judgment of justice. But what I say, the statement on the judgment on onenya from case war your friend is saying omudi in the US. Why you video nyana?
First of all, my main case, as some on more transfer no. Say be a blue judgment in there, MI. Judgment about e be an opening and ask or obi. Na say they was here to true me car. Where they kind senior bas social media be kan ho asem or judgment here. We as well how we fa copy by. Judgment they send the judge will Ghana mpokura ade charity me apply say judgment na ready at the bed ya the copy bed e be ma and we sure say na so judgment and come find the MI na ade ba ko say tia say okokota if it be reliefs the reliefs are what you want the court to grant you na e be a whatever ade a wo hwehwe no court no say court ade we na me there me hwehwe if you look at them
let me just correct this he made a video entitled it the video as the arc of justice, a triumph for truth and accountability. And then the statement, the other one I was reading was on the statement on the judgment by Ghanaian court. But we know caption, press release by Anas Aremeyaw Anas after the U.S. Essex County Court victory. Meaning victory, so that it comes out of judgment. President said, we're dealing with him.
Well, you know, Anas is a very intelligent guy. And he's also a lawyer. And to Osha, on Ghana matter, he was able to make a very firm statement on it that is a judgment. But we don't say a victory. Victory, there you define what you want to call a victory. Could do sprinters. Be a union person, and anti could do Sacomona ha. Now, Sacomona ha, me, my dream would ye. MC me do KFC. Metimako, to me, it can be a victory for me. I don't know one guy say, hey, the judgment of the court, but what's a victory? And the victory is very subjective. Then to him, no, when you go to court, you are looking for a lot of reliefs.
Okay.
Right? The reliefs, could be the damages you may have the actual damages. You may have the compensatory damages. You may have the specific damages. Or even the punitive damages. Sometimes you even want to clear your name by the decision of the court. And the DC court, if you look at the total reliefs that Mr. Anas was seeking for, that was in the region of around $30 million.
$30 million.
Yes, but yes, still, the jury granted $18 million. In jury trial, they do not deal with the law. And one more decision be on they don't have to ground it in law. Say a judge in a same way, so judge be anywhere on any normal day, even probably guarantee even $500,000. Because also in the judicial precedent to buttress all the damages are there or by jury there, one jury you just have to play by emotions. Na me Anas, many Obama shiapen, many Trump shiapen, many Kofi Annan shiapen, my reputation pa, any person may see a so best reputation. Waka can say be a good movie. Jury only any legal training or no DNS factor any panampa or heard the factor na what causes defamation. And so the jury more or less, or technically awarded $18 million. But adeba kwa
enti mukotua na meka mukotua mbo nya wona ukotua me wrong ni eja mukotua
enti maminchim ontua because
how
ontua che say
jury na make
it there be na meka ba me chemu no say ukọ particularly if you look at the American system in terms of one more use common law, you use common law. But of course you have some states one also of some form of hybrid system no more any other kakra no more kakra it differ. Now, even in Ghana, when a jury comes out with a decision in criminal proceedings, if be said, the judge will have to enter the decision of the jury before it becomes the final judgment of the court. In Jabibi, also say the verdict of a jury is not the same as the final judgment of the court.
Okay.
Indeed, a whole confusion here. That's why Anas was very. He's an experienced guy. He's a lawyer. He's a very intelligent guy.
And he's saying that he's been victorious.
Yes, because
this is why you're victorious.
Yes.
Now would you say it depends on no scope or bedita and say no any victory. Why would the KFC nanti? Why do you say he's spending?
Yes, you see, when in a matter when it doesn't only involve you, and there are two parties, and there is a final adjudicator in the matter, when you are making a presentation of that matter, you present it objectively, not subjectively. And within that context, you cannot tell me, say, to you, you have been victorious, especially when you know, say, the interpretation that the ordinary person on the street will think and place on what you have written means, I don't know, judge and I make judgment. But meanwhile, there is no judgment.
That is why you say he spent.
Yes, that's sorry how he has spent it. If you ask me, he has spent it.
Because he stated, say, media jury, essay, medim kunim.
No, you see,
$18 million.
When you say about your subjective view about the verdict of the jury. Anyway, Ohene Agyepong could also come and claim, say, because after all, maybe I will pay $30 million in 18.
Oh, no, to me claim because he's on a video. He's on record on a video. Say, me Cashman, me fight. Now, with Cashman, about $80 million. I don't get what.
Oh, you see, because of your platform, I don't want to really digress into other Bonibeka said the peripheral issues, the issues of periphery. I want to stick mainly with what will happen in the court.
Okay.
Let me state on record. To say, as I speak with you, there is no judgment of the excess county court. There is no judgment.
Can you say na etiefo person motiase? Yes, say trial. Yes. When it comes to jury trials, jury need determine on fact we na omode your friend say omo verdict ba. Omo verdict na eba. The court must enter it into your friend say it to be the final judgment.
Yes.
But that is just procedural.
Yes.
So judge will just enter it and Kennedy is to pay $18 million.
Yeah, but you see, say there is a very fundamental reason why your court as a million quarter honka say we are say as judge nebua. Then we go through procedures. Each and every procedure in law is as important as even the decision of the court. Because the procedure no umisi bi ba kope and no quite to be constitute grounds ma the whole as enkoma edim na ede invalid. Now some also
so in this present instance are you saying say Kennedy entria oninya for Kennedy Agyepong ontria $18 million because you believe said there are some steps that has been sidestepped or there are some procedures that has been sidestepped.
We a student lawyer. Ade say what say before you be court obi ebetimaka say yabo obi ka no court assembly obeka bia an order of the court. It is the order of the court no and how the court into be a friend of execution. Execution it say order na court no kan o dey koye adwuma. But as at now there is nothing like an order of a court that will be executed.
Dispute we all know that there is no order of the court, so there is no judgment of the court.
Yes.
It is only the verdict of the jury. What I'm asking is that the verdict of the jury ordinarily would be entered by the judge to become the final judgment.
Okay,
provided say per the well kind said there are some fundamental breaches. The point is jury we na adwuma yewura Kennedy Agyepong ya boneka $18 million. Adenti na wo kan kwasi kwatin lawyer wo ka say in this present instant no yewura Kennedy Agyepong entua say sika no adenti
even Ghana ha kwa no wo dey so through a criminal trial ho before jury ni wi o madwuma na judge na be a friend summing up
good
Wabebo the jumedi omudi nyina tofa. I reminded the jury of their responsibility and instructions or their day. Amom.
And no before say jury ne kwakoye na juma. I think they sum up and give it to them.
I mean, but bottom line that the jury are giving instructions.
Okay.
The jury don't just work in a vacuum. And so based on the instructions, if you miss any point in the instructions that the judge will give you, it constitutes a ground for mistrial, which I think I will come there. But I don't want to jump ahead. But say a fan of Marco. America court no, ordinarily in many instances the verdict of the jury in most instances are entered by the court as a judgment of the court. What I say? Indeed, verdict in by or atono. Now, so America jury trial, their system is to the effect to say, jury no, decision are not based in law. So if in America, when a jury award damages against you, you almost be remit. I need to check the spelling for you. I not just say because the jury's decision are not necessarily based in law. No, they can go in so much excess. Okay. So you have recourse in law to even mitigate the decision of the jury. And over here, Kennedy Agyepong lawyers, nobody can file even this application. Yes. Nobody can file this application. Say, scarecrow judge in the kind. It's so excessive. One who use the word be say it bigs the sound conscience of justice. And ordinarily court that alone presupposes that even if that application is heard, it makes the verdict of the jury not absolute. And for that matter, even the verdict of the jury is subject or is amenable to changes. Because if there is a room within the same American legal framework, that jury require pass a verdict is amenable to changes based on the defendant, one application will be making quarter. It presupposes that the jury's verdict cannot be absolute. In this context, jury verdict is not absolute. First, even the application on where say to mitigate a cost on the form, damages the form. One, the court has not even heard it in the first place. Secondly, one mu jury na verdict no one mu verdict na wie na before mbe enta no e wo say yeti say the jury are given straight grounds on instructions also
they have to work.
They have to work. Jury no making mistake biara it can constitute a ground for the other party to draw the court's attention. Now jury no one mo nya judge for ni no one mo ye a single mistake pair the assumption or the presumption they say then they could have as well made mistakes in the whole trial process. And on that dey be a fair mistrial dey eba. Yes.
Meba.
And that is the stage
and meba ho abunwachi. So we say me say jury no me I think say TFO will come to the conclusion say the verdict of the jury is not absolute because it provides there are some two instances a bit messier. You can
even mitigate it.
Good. One, mitigation. Two, the grounds for mistrial.
Yes.
But say Yera Kennedy, the lawyer said he can file for an application for mitigation.
Yes.
Is it a ground that Omadia to say my client Yera Kennedy Agyepong? You
see, the jury's verdict had already come. So as for the jury has found him culpable.
But the lawyers who are representing him agree to the fact that he's culpable.
Yes, the jury have said that.
So the lawyers agree.
Yeah, the jury have said that. But you see, that cannot be a statement of record as at now, unless same is entered by the court.
I agree. So let me even veer from that. Now let's come to mistrial. Say, name feel that the paper as Obia Museum is criminal matters because to the beer you see the processes and others are one way yes I step here to the being so I bet yes ya far way I bet you way I say yeah for so we am gonna give you witness and others. So personally is an area me focus on me just akwanya yi so abo me lecture Kofi Same and my Lord Jambibi, also actually at the criminal procedure. I'm a menya Santia, so I've developed much interest. I know for a fact that about criminal procedure, be far hudi everything. Me use criminal procedure because in Ghana in criminal procedure Ghana has criminal procedure a jury trial.
Yes.
And as some of the offenses, the height of the punishment in yes a jury trial. About criminal procedure, you be far hudi everything nsem jury you making sure say they should based on only facts.
Yes.
And the court will look at the law.
Yes.
That is the difference. In the procedure no say any step be
yes.
and be a friend of mistrial. So mistrial aye hunyai. Oko America use jury trial for or the jury for a civil matter.
Yes.
Meaning say jury no enim emra no. Court na emra ne hye ne kete say court na judge na ebe same up emra no ama no instruction. Into okoba na we di instruction so na so okobro instruction so a ground for mistrial.
Yes.
Ko san ya me pese ye ti ase pa ne say ye ka mistrial na kra mra ni ni eno ne den. Because trial ya messy e miss kwara.
Yeah, say I did cry we can say come here pon because what chire ye kra say the busy at chim. I say mistrial ni nyina che say o say court asem no. Before trial and kasa ebe koso no there are processes preceding the trial. Ebi a mo be file mo processes. Na fe mo jitum say ampa bo a mo file process kwa court require to make a choice bia mo kwa arbitration. Na mo ko try say bitima sisia. Ebo so mo timi kra file se bia mo ko person ko settlement. Na mo the terms of the settlement na the abana court na adult. Na mo nya CMC wie my friend say directions one when they gini nyina wie na afi ye full trial say there's asem no ye twaso ano no. So na trial process no a process any event, and of course every process contains its own unique procedures. So na procedures no usually no the whole idea about mistrial what the Ghana have for instance is situated within the context of Article 19. Article 19 guarantees fair trial.
Okay.
Article 19 say say you accuse person biano.
No one member because my way attached to mommy.
Yes.
My musa back and forth.
Yes, the basic ground and the inspiration is rooted in Article 19
of the Constitution.
Yes.
Okay.
Yeah, because the whole excess or essence of trial is for fairness and justice.
Okay.
So, and if there is adebia ma fairness na said the whole trial process no etechima so that any of the parties will not be treated fairly in the trial process. Then the court is of the view that it is proper and a better procedure and a better practice to invalidate the whole trial procedure. After all, it's our option to even do the trial again. The idea be a cause a fundamental, any fundamental error a be affecting the fairness of the trial. And I say, it be a question the credibility and the integrity of the trial process, and no will be or constitute a ground for mistrial. And for that reason, trial the fairness. Said the bear at the end of the day, no, young will be a baby na fee be at chima na a free trial no home for so
be saying any bit chima.
Oh, say a be an example jury trial. Some can say jury one money. They are not people with legal training. Now one more better than more instructions based on the court or the bench instruction. Now instruction cry jury need more mono. Now sorry court no na judge need more mono. A feeble instruction or more the for cry. Okay. We found who dinner. In that case, it can constitute a grounds for mistrial. Okay. So in that instance, no, ebisukura or ha, you are a trial be or ha. Ebi a judge a crowd trial, no, so nobody can crack or cut trial no one same or public. That be can constitute a because trial or the old Ebukura jury, we a member of the jury. Oh, assembly now to sworn and can assembly year. I did say books a case before for no more interview. Now which are wondering, hey. Won't that be an indictment onto the trial? We are lawyer crowd. Yes, you say. I feel we said the court documents and not the number one be a judge. All those are grounds. It questions the integrity of the trial, and those could be grounds for be a fundamental errors. Be invalidity, the fairness and the integrity of the trial process. And in that matter, to invalidate the trial. It's on that basis, you know, you be say attention if we are to go by the straight trial na. So the fair thing to do is to invalidate the trial, and that becomes the grounds for mistrial.
What chirimuye? Kwesi kwatin Esquire. Actually, Facebook. I'm a Ghana for to say verdict of the jury. Enye the final one.
Yes.
Yenyina ya jiatu. Wachire mu ene manyanti ase ne kama. Na woka kura kusi say there is a whole ground for mistrial in the Anas Aremeyaw Anas versus Kennedy Ohene Agyepong.
Yes.
Which ground have you seen? And should we believe same say enunti $18 million no? Though mitigation has been found before, say mitigation, $80 million na have it no. But we'll say the process of the jury, the process the jury went through no, and what chema and grounds for mistrial, then and what chema.
I never quite say what say. Lawyer be on strategy or deba asemu. Ebua was a mayor the bar born when your life papa was a mako say. So na lawyer for the one would me deal with the say, we even find technicalities. Ebu ano check loopholes so asem na moye de moodin. Most jury divided taba. Court na enter into the record of the court. It becomes a judgment of the court. But almost the court, yes, so testimony na where the cigar with the jury no no mun de omo yes so pa. Onu nka so mun for. They never challenge the verdict of the jury, but they are only filing sa process and they say onu mitigate the cost. Na ade ba ko a esi was asem we mu say one more judge in instruction the more no judge no say ye be cheche the damages near the emu car ye de ebo ewura Kennedy Agyepong. Now before that my encha dey move just briefly ye woko court a reliefs are open no in civil matter no kaka won say criminal matter there nipa no conviction ba ye nipa na ekọ de ekotum ni a sentence na kotum eno ye ntwa kapra ta kunya de emu bia. But when it comes to civil matter and their damages no pecuniary you be say yesika na be there you be quantify in monetary terms na atwa there amasimasi na obenten na damages you want who dey be you have the actual damages, you have the specific damages, you have the compensatory damages, and you even have the punitive damages. We are same way you see here that court in instructions very clearly say one more damages on back calculating because those were the damages that Mr. Anas was looking for. Was it Kennedy Agyepong is some okay good hufi pa a good hufi hano amo how are they atono so say be won am kwani pa ye dey eshe no amana no nyam ni bu o ye dey nyina ye dey eswate nti you categorize all this into damages. Na ya de ho sika ya de amount.
Be compensation.
Be compensation, be actual, be specific, be say. Enti ma man etiefo nti ase. Ono I say bia wo a wo kura tipa track. Na the tipa track na for about taxi. Wo di ko bo mu taxi bia 2 months esi magazine. Afei na yes so.
Taxi asem na wo kanya Mazda.
Taxi ebi esi magazine magazine ya de bosu mienu na be de ebe taxi driver nkwa dwuma da and the first time car the car na was say no those are the actual damages you pay for the cost of the repairs of the car free wa we free actual damages eno kwa ho back compensation because nipa ne bi kwa 2 months nkwa dwuma da na enye ono na hebusu you have to compensate him after we free compensation no etimi ka cho say o car na wantwi ne yie no wo de abo nipa de na so yo se atwe so punitive na we are seeing hu say wo the car bo we are so train be de ebe ma those are punitive damages na yewura kere Japan no ma asem no those other damages no they had rewarded it wo sha initially no share rate no so pa na what they believe that Mr. Anas was looking for what means jury no jury ni bo ha bu chemu mienu be bo also per 10 no my 5 be bo per 10 no my 5 be bo also per 20 ni be my 8 I mean
Anas also say an award of presumed damages in the amount of $5 million United States dollars.
Okay.
An award of special damages in the amount of $10 million.
Okay.
An award of actual damages in the amount of $5 million.
Yes.
An award of punitive damage in the amount of $10 million.
Yes. And the damages you pay, court no
per 4.
Yeah, court GGB and I see 30. The court GGB 2 me the court damages no you know jury GGB 2 mo no. Na instruction judge na jama omo say mumfa damages munchemu 2 punitive damages in there me no ma be trust na ahwe kwan ya de be de ebe fa so and the ade chen ya won mo be trust so mo ka punitive damage ni ho asem no ana jury ni say oh I ho asem na aka da bi already $80 million said by shemo ana judge ni say ai ana asema me ka man ti ase ana
America America
oh na say twini ya kanti
kwasi
and the penny say, hey, that's my man. Yes, I'm a you. And I make us a law is all about strategy and tactics. Honor, you reckon Japan lawyer, sorry, I'm say, hey, go for a trail from not to come. America president say, oh, be brain say, injury. You see, I mean, carrying from in America, in about 90 or 95% of the cases, when a jury make a decision, a court on is because they are of the view say. The jury reflects the average person living within that jurisdiction. Na jia owo dey efa court no ho. And the jury cast mo nta anya dey. Ensesa no. And I know the one here ho be kire. Nemom so there are also a lot of authorities and a lot of legal precedents say as soon because the jury are also not lawyers and they are not properly so-called legally trained. As soon as the jury makes any minor mistake within the judicial process and the trial, quickly it constitutes a grounds for mistrial. And the one you were Kennedy lawyer sorry, no, hey, na mo direction court to them mo direction say we antiase. No say hey, na mo antiase we na mo antiase any the court so na mo tiase. No mo sorry catch judge say owura. Your precedents also say jury na antiase etimi file say trial no the court so nyina no it has been invalidated. And if you continue with such a trial, we will incur huge injustice and unfairness to us. And on that ground, no, we are filing an motion for mistrial. One more kind of judge and say, "Na mo mas mo okay, I'm going to say mistrial application. You file on a ura. Mo family on the court record say mo de chokrata so ye by. So the court gave them 7 days. Say 7 days on mon famra. Now on the baby the court have 30 days to rule upon it. Now as soon as Ube raise the issue of mistrial on the verdict of the jury because it enters same as the judgment of the court. It places what I would describe as a hallowed injunction on the verdict of the jury. Now, so just as now, there is a hallowed injunction on the verdict of the jury.
But has the mistrial application been filed?
Yes, it has been filed.
It has been filed. You can confirm.
Yes, yes, it has been filed.
Hey, who are interested with case?
Say you settle that. Ubetiemu ye nwetima chemu ye.
One yera Kennedy Agyepong lawyers ekasa.
Oh, I'm not mo kasai.
One Ohene Agyepong.
Me no mo kasai.
Me gidi say who interest kra wo case mu say Kennedy ankasa.
Oh, me de unua pani de sebio asem fa Ghana ho bia me de chebi. Nti we so ka ho bi. Na wa no me se makoye party asamuntia na me party for so mo asabi asa media chepa.
I see. So the next action is for the court to have the 30 days to rule on it.
Yes, and it is important to also material who say by virtue of raising of the mistrial application, it places an automatic injunction on the verdict of the jury. Because until that mistrial application, a ruling is made on it by the court, the court cannot proceed to enter the verdict of the jury as a judgment of the court. And the outcome could be say one more committee I say mistrial application one more urgent mistrial application it will say trial processing in a one more anyan so there then the court will now have to then look at an existing application a Kennedy no a lawyer say yes one more enter so
Mami Musa we the engagement interview by we say court neje mistrial application ituma.
Yes.
Can the court order say yen start case now fresh and now say obetima boegu? What is the effect?
I've read legal precedents that most times they left with the discretion of the court. But in many instances, it constitutes a grounds or basis for retrial that they can do the trial again, provided there is no issue barring by virtue of double jeopardy. What I say?
This will not be double jeopardy.
Yes, I know.
Double jeopardy.
Double jeopardy, they say, acquires a seminal court to a didada. Now, be a once had a seminal the echo. But within this case,
and I said to say, be a wabokrono.
Yes.
Offer at 29 kakron.
Yes.
It means we offer at 4 Francois. A cat chronoasm. Now, for ye,
yes, the same set of I mean, the same offense, even from the same facts. It will not augur well. That will be double jeopardy. But in this case, in many, of course, I don't know operate within the U.S. jurisdiction. But in many cases, when the court rules for a mistrial, it means that the parties have opportunity to go through the trial again. But mind you, trial there, they are not bound to. No, we are where anybody can bound you to go for a trial, unless in criminal prosecution where we are accused there, you don't have an option to say, I'm not even going for the trial. That is it. But Adebako say, even assuming without admitting, say, well, mistrial application is a court no subogua. Not even the entire judgment against Honorable Kennedy Japan. Say, but we are a student of the law. You know, say when a judgment comes, you can go to a higher court, mostly to even stay the execution of the judgment and also file an appeal against the judgment. And he said, when I see district court, let us say you have to escalate it Ghana to a circuit court. Circuit court, a happier. You can go to the higher court. Higher court now you're happier. You can go to the court of appeal. Court of appeal now you're happier. Obeti miso court, a beer of friend say Supreme Court. Na also one of my haka.
Supreme Court crown you happy obeti
review.
Na res judicata.
What's that? Yeah, manson watch kakra we are zenya na no go for the ko mus. So person the call the Arabia akobi. This oh no want emi anu mo free mus buy. So mo ba no ayi butch butch we mo no. Oh, okay. Williams and Sunita Williams and one oh, no,
metra asasi so cost.
No more watch the moves over. I was a comedy 8 days spend no more. If you didn't cause say, Diamuko did 9 months or no more hangy him. A whole dark crowd hang ho. Oh,
money.
Oh, did he? Now, I said, you have a no, there was a good for our money. Continue ho. And he ebi ana nasa for no more than you are not come almost smart shipment at the space of the come on.
I see.
But ebi are not near the just to sustain you. We hang you e no quite hang ho. Omo da come hang omo ye bibia omo hang. I'm not no about 9 months. Na Trump about so kwa for maba.
No de omaba.
Adwuma na omo ye dada no obeje fans amano.
Hey. Many are very medase. Many say, oh, in the final ways, we are with the we are so grateful. Why are they trusting me? And because I'm saying personally,
that's how they don't have a chile
there be a no credit. But you say, in the next line of action, we are not law lab yet.
Oh no,
boy, Naja, what they are baby for say, Naja, what boy am yet video. Yeah, that's it. Ladies and gentlemen, thank you so much for sticking through with us. Yeah, the lawyer Kwesi Kwarteng and Edi Nkomono, or a formal spokesperson for the Ministry of Education. Is there a private legal practitioner? Is there a lawyer Nina Framaimwa? And when I see a private legal practitioner, no, is there no? Say Kennedy Assembly, Dimuntin Mine Pano, Yera Kennedy, Japan Assembly, Dimuntin Mine, Brebiana, Pink Rabbit from the law lab, Yenfency, Yabamo, na Babity, Yabana, sorry, not Yababity, no. Can I say over like it, no subscribe, no share, no comment. It is the law lab here. We dissect and unpack everything legal. Medin chakese pa Emma minua penny me bra penny meja otumi for pa former district chief executive for Asene Manso Akroso DCE Inkum was no word no cre na de aka no or de atoa so nyamishe nyina. This has been the Lord love. Thank you.